I think I'll use this one as don't use, okay, I will not use this one. All right, thank you for having me. It's really, really great to be here, and I've enjoyed learning so much about NFTs and metadata and all these innovative approaches. And you know, that's what it's like basically being in Peter's orbit is I'm always learning tons of interesting stuff. It's just fun to be in this space. So thank you for having me. So what I'm going to try to do here, I'm going to go kind of quickly. I want to give an overview of how copyright interacts with books and what some of the latest developments in the law are, and particularly with respect to accessibility, which will set us up for a conversation with Bob Martinengo and Carolyn Desrosiers, who will be joining me in 20 minutes, 19 minutes now. So I want to start, look, copyright has always been about books. The very first statute of copyright in 1709 was, of course, about books, and in fact, copyright law was invented essentially to deal with the printing press. And so that's something to keep in mind. In the United States, we've had copyright law since the inception of the Republic. There's actually a constitutional provision for copyright law. Most of you probably know that. Fair use was actually developed in 1841, so not too long afterwards. And there, essentially, the Justice Story said, well, we need to figure out how to handle what infringement actually looks like, and how that conflicts with other values we have, like freedom of speech. And fair use is actually the right to make use of something without permission or payment when you're doing so for certain types of uses. Otherwise, and the image you see on your right there is the Bill of Rights, because otherwise copyright would run roughshod over the First Amendment. And so the Supreme Court, and the best way to think about fair use is, when you're litigating, it's presented as a defense to a copyright infringement claim. But when you really think about it, it's a right, because it is what upholds our free speech rights. So just a story here, we have a 12-volume set of books that was called The Writings of George Washington, and then someone else came along a few years later and created an abridged version that was just 2 volumes in size, and they both have letters from George Washington. If you're a Hamilton fan, there's lots of Hamilton content in there about Hamilton beefing with lots of people and getting in arguments and asking George Washington to vouch for him. I'm not going to talk too much about the 4 factors for analyzing fair use, but these were actually enshrined into law by Congress, or into the Copyright Act, the Copyright Statute, in 1978. And these 4 factors actually correspond with the factors that Justice Story actually developed all the way back in 1841. So these 4 factors involve how you're using the work, how creative is the original work, how much of the work you're using, and does this conflict with the market that the original work, for the original market of the underlying copyrighted work. In 1994, the Supreme Court really changed and in my view, really moved copyright law further along in the law of fair use when they created the doctrine of transformative use. So the idea is, okay, first thing we do is look at how you're using the work. And in 1994, Congress said, well, or the Supreme Court said, well, transformative use means, are you changing the way that you're using the work in a way that adds value, that adds new meaning, that adds something new to the discussion, right? And it was actually a case where Two Live Crew sought permission and was rejected to create essentially a cover of Oh Pretty Woman. Theirs was called Hairy Woman. As you can imagine, it was not a very safe for work tune. It was very sort of making fun of the wholesomeness of Pretty Woman, and the court said this is a parody, and this actually is a form of criticism, and it allowed the Two Live Crew song to go forward, right? So I'm not generally a fan of large blocks of text, but the idea here is the court said, are you adding something new, or are you just superseding the object of the original? And this was transformative use, right? Are you altering the first with new meaning or message? And that gives the freedom of speech breathing space within the freedom of speech, breathing space within the confines of copyright. So we have Gone with the Wind, and a sequel was written about 15, 20 years ago called The Wind Done Gone. It was Gone with the Wind told from the perspective of an enslaved person, and the publisher sued, and the publisher lost because the court said this was a parody. And then later versions, you can see this little sticker that was put on the book. It says unauthorized parody. Meanwhile, and that was in the 11th Circuit out of Atlanta. Meanwhile, up in the Second Circuit, the First or Second Circuit in the Northeast, an English professor wrote, Eric Dorlinger wrote a sequel called To Catcher in the Rye, called 60 Years Later, Coming Through the Rye. And the Catcher in the Rye people sued, and the Catcher in the Rye people won, because it wasn't enough of a parody to constitute criticism and commentary, because a sequel is an old-fashioned derivative work, the same way you do an adaptation from a movie to a film. That's not fair use unless there's some criticism involved. Now, it can get more complicated with something like critique, and we see that with art quite often, right? So now we have a case that actually was argued on October 12th in front of the Supreme Court. I was there. I went to Washington to observe the oral argument. I did not do the oral argument, although I wish I had, because I didn't really like the way the parties handled it. But that's another story. So this transformative use, parody over here versus straight up sequel over there, that makes a lot of sense. But when it comes to art and some other types of expression, it can be a little bit more difficult. This case is a really difficult case because you started with a journalistic portrait of Prince that was licensed to Vanity Fair to create this article about his fame called Purple Fame, and this is back in 1984. Vanity Fair said, we want something that's more about fame and celebrity, so we're going to commission Andy Warhol to create this purple and watermelon-colored picture of Prince, which he did. They credited the original author in the story, and then Warhol, nobody really realized this, Warhol went and made 15 more copies in different ways of these portraits of Prince. And Lynn Goldsmith never knew about this. And in 2016, when Prince passed away, Condé Nast created one of those, like a whole magazine dedicated to Prince. They licensed this orange portrait you see on the lower left to. They got a license from the Andy Warhol Foundation, right? Because they said, well, we have to get permission from him to put his art on our cover. And Lynn Goldsmith said, hey, wait a minute, that's based on my photo, and she sued. So, in my view, it's very obviously fair use, right? Because he's doing something totally different. He is creating art. He is not creating. This is not a journalistic portrait. This is not an artistic portrait. This is a whole statement about celebrity, about how you construct an image, and that's why it's been so influential. It's about a lot more. And of course, that's why Vanity Fair back in 1984 and Condé Nast back in 2016 wanted the Warhol print instead of the photo of Prince. They wanted something more that spoke more to his status as an icon, as a celebrity, and so on. So the district court said this actually isn't very hard under existing precedent, under transformative use. This is a transformative use, and so the Warhol Foundation wins. The Second Circuit said not so fast, right? Because here we have a magazine licensing a picture of Prince, and that's what we had back in 1984. A magazine licensed a picture of Prince. So it's a picture of a guy's head. It's a picture of a guy's head, and that's all the work we need to do here. We don't need to think about adding new meaning or message, even though that's exactly what the court said back in 1994, and 300 or 400 courts have followed that since then. And so the court said, here, this is competing with the original Prince portrait, and it shouldn't be. And so the Second Circuit found for Goldsmith, and now the Supreme Court is considering it. So what does this have to do with books? This isn't as directly relatable or directly relevant to books as a lot of other cases that have come in the last, since Campbell, dealing with fair use or dealing with copyright law more generally. And let me talk about a few of those now. But the reason I'm bringing it up is because this could totally change fair use as practitioners and users know it and have known it for the last 28 years, because we don't know what the Supreme Court is going to say about this doctrine of transformative use. So here's a really good example of the doctrine of transformative use in the publishing context that pretty much everyone in the room is probably familiar with, right? Google book search, right? So 15 years ago or so, Google said, hey, you know what we'll do? Let's just digitize a bunch of books without permission, and then we're going to have an archive on our servers of all these books. And then when people do a search, we will do the search result. We'll make the search results known, and then we'll actually show little tiny snippets so they can see how their search term was used in context. And this is actually a screenshot from the case. Now, the publishers and the authors sued. Each side spent probably over $100 million litigating this. The case went on for many, many years, almost 10 years from start to finish, maybe 7 or 8. I mean, it was a long time. And what happened was they actually reached a settlement, the Google Book Search settlement, and they said, okay, you know what we'll do? Let's make peace. So we will, Google said, okay, we'll keep 1/3 of all the ad revenue we get from this. We'll give the authors 1/3, and we'll give the publishers 1/3. Everybody be happy, right? Not so fast, because the Authors Guild and the Publishers Association do not represent all authors and all authors of books. And what the parties said was, oh, for all those other things, we're just going to split the difference. And the settlement, if approved, will give us the exclusive right to do that. And so basically all orphan works, right? Who knows what an orphan work is in the room? It's a work where you know it's under copyright, but you can't find the copyright holder, which sucks, because as soon as you want to do something with that work, here comes the copyright holder. Sued, injunction, damages, you can't use the work. So because we have copyright essentially by default, we can't do anything with orphan works, and they're just in stasis. So this is a really nifty way to unlock orphan works for Google and the Authors Guild and the Publishers Association and no one else. And this raised all kinds of antitrust issues, and all kinds of people were saying, hey, wait a minute, this is totally not fair. So that ended up being struck down by Judge Chin in the Southern District of New York. Then the case was not settled anymore, and it kept proceeding. And then we had the Authors Guild versus Google opinion that eventually came down in 2015. And what the court there basically said, look, this is a great example of what the court was talking about with transformative use. Look how much value we're adding when Google scans these books and makes so they're making preservation copies, when they do searching, and then when they make the snippets available. This is not affecting the market for the book. This is only helping, it's not hurting. And so the court essentially said, because of the way it's done, this is a slam dunk fair use. Now we have another case called Hachette versus Internet Archive. And this is, I'm going to get into accessibility a little bit, and there's some fair use conversations we can have there as well. But the Hachette versus Internet Archive case is essentially, so who knows, we heard from Brewster Kahle yesterday. I couldn't be here, but he talked a little bit about this case, is that correct? Yeah, right. So essentially, this started with the National Emergency Library during the pandemic, right? We had millions of books sitting in libraries not being checked out, and the Internet Archive and a number of other libraries said, well, what if we gave digital copies out since all these people are at home on lockdown? And the publisher said, how dare you make these books available to all these people on lockdown, without our permission? The National Emergency Library is no more, but what we do have is a practice called controlled digital lending, right? And the idea is Internet Archive and several other libraries and numerous other libraries are saying, okay, if we have a physical copy sitting on our shelves, we will loan that copy out, and no one can check the physical copy out, and no one can use the No one can check the physical copy out, and no one can, and we can only check one copy out at a time, right? And some of you may have done this. Has anyone done a controlled digital lending ebook rental or check or loan? I have. I even listened to some audiobooks using controlled digital lending. What's funny, kind of ironic about it, is it uses DRM, right? It uses Adobe's proprietary technology to ensure that you can't make a copy, and that when it expires, you no longer have access. That case is now, it was filed in May of 2020, right at the height of lockdown, by several publishers. Hachette is the leading one, and I might be pronouncing it wrong, but that's just because I'm a dork. But it's really interesting to see. So now they're in what's called motion practice, right? So motion for summary judgment is basically saying, all right, court, you can, even if you construe all the facts on one party's favor, that's fine because we win as a matter of law, right? So you can throw it out, even if you admit all of the facts that they want, all of the undisputed facts, you can construe them in the favor of this other party, and we still win, right? So both parties have filed motions for summary judgment. There were a bunch of friend at the court briefs, which is somewhat rare because this is in trial court, and most amicus briefs come in at the appeal court at the Supreme Court level. And it's very interesting to see how the two parties characterize what's going on, right? So if you read Internet Archive's briefs, they're saying, hey, never in the history of the United States have libraries needed to obtain special permission or pay license fees. We have always been, able to lend books as we see fit. Now they want the right to control how libraries lend books, right? Sounds pretty compelling. But the publishers are saying this is, industrial scale digitization and distribution of full text digital bootlegs for free. Something tells me that if you went back a certain period in time, you might find the same comments about brick and mortar libraries as well. But they've been around so long, maybe not. So people are watching this fairly closely. Some people think that controlled digital lending is perfectly appropriate and makes tons of sense. Other people think this is kind of pushing the envelope. I think the publisher's strongest argument is we actually have all these, and I don't have to tell people in this room this. People, these publishers have whole business plans and internet streams, and revenue streams, and everything that are based around distribution of electronic books is very different from our print business model, right? And so this totally disrupts that business model. And if they are able to say that and convince the court that, then they would have a better argument. But a lot of amici friends of the court who wrote in, as well as the Internet Archive and the other defendants, are saying, actually, this doesn't affect your revenue because this is no different than a physical book. The only difference is someone can come in. So of course there is a difference, which is I can borrow a book from San Francisco even though I live in Irvine. So we'll see how it goes. I can't predict how it'll go, so I can't predict how it'll go. Let's talk a little bit about accessibility. I'm going to fast forward actually to one internet, to one more fair use case, which is Authors Guild versus HathiTrust. So this is one of the Internet Archive's digitization machines, where they digitize books, and the way they do it is they have that single lens reflex camera up there, which takes a picture. The glass goes down. The glass goes down and makes a flat image of the book without tearing it or hurting it. And it's pretty interesting. Some of these are actually foot pedal operated, so the operator can do this, and move it down. It takes a picture. Anyway, that's a tangent. But here, what happened here was HathiTrust is a consortium of university libraries. They basically did something similar to Google Books. They said, we're going to make a full-text searchable database, and then we're going to make accessible copies available to people with print disabilities, not to the general public, people with print disabilities. And the court said, well, that's fair use. And it's interesting because the searchable database part, the court said this is a transformative use, all the way going back to Campbell and this case about the song parody. And then, of course, it's evolved into other kinds of uses like Google Book Search as well. But making works accessible to the print disabled, the court said that's actually not a transformative use, but it's still a fair use, right? And if you look at the statute and you look at the courts, they've said fair use can be expressive uses like parody, criticism, or comment, but it can also be educational uses, research, scholarship, news reporting, and so on. So there are lots of ways fair use can actually be applied. And so I want to now welcome my co-panelists for the next panel, which is about accessibility. And I'm gonna start off by providing a little more legal context. So here is Bob Martinengo and Carolyn Desrosiers. And so I'm just going to talk. I've got a few more slides to talk here about copyright law and accessibility, and then we can begin to have a conversation about accessibility. Not really about accessibility law as much as about questions of accessibility and the publishing world. So the Chaffee Amendment is an amendment to the Copyright Act, right? And so copyright law, there's some judge-made law like fair use, and then Congress has passed, the Copyright Act, which looks like the tax code. It's very thick and it's mostly very industry specific. They have stuff for cable, they have stuff for satellite, they have stuff for libraries, and so on. The Chaffee Amendment basically said if you're an authorized entity, which is a nonprofit organization or government agency, and pretty much includes all schools and libraries, you can reproduce or distribute copies of works in accessible formats if they're done exclusively for use by print disabled persons. So that doesn't just mean blind individuals. That also means maybe someone who needs large print, someone who can't physically turn the pages, and other things. So then we also have the Hothy Trust case, which said, well, the Chaffee Amendment does protect the Hothy Trust organization or consortium, but even if that doesn't apply in certain cases, it's fair use, right? So Hothy Trust essentially took the Chaffee Amendment and expanded it. That is John Chaffee, who was, I believe, a senator from Rhode Island. The Digital Millennium Copyright Act was passed in 1998. Most people, when they hear DMCA, they think, okay, well, this is like, I got a DMCA takedown notice because I uploaded the latest Marvel property to YouTube, and the DMCA gives a safe harbor to YouTube and Reddit and all these other platforms if they take stuff down expeditiously and jump through a lot of other hoops. But one other thing that the DMCA does, that passed at the same time in 1998, is it makes it illegal to rip from or break encrypted content when that content protects copyrighted content, or excuse me, to break encryption or other kinds of technological protection measures when those measures protect copyrighted content, right? So encryption on Blu-ray, encryption on ebooks, Adobe's, DRM, these are all things that have special legal protection in the Copyright Act, and criminal and civil penalties if you break them. So when this was passed, everyone said, hey, wait a minute, if you're gonna do this, it's gonna essentially become a giant land grab for copyright holders and make it impossible to make fair use, right? And so Congress said, all right, let's have like an exception to this. We're gonna give the Librarian of Congress the opportunity to issue exemptions that will allow certain uses or users, if they're doing lawful things and it's being done appropriately and responsibly, we'll give them an exemption, right? So a good example is I do a lot of work with filmmakers, and so back in 2008, we started going to the Copyright Office every 3 years to try to get exemptions, to say, hey, our filmmakers, if I want to make a film commenting on, well, we're here in the Italian American Club, The Godfather. Let's say I want to make a film that talks about the relationship between The Godfather and real life organized crime. Fair use would allow me to do that. If I did it responsibly, Paramount would never come after me. They would have to pay my attorney's fees if they came after me, because it's something that's really not controversial under the law. But in order to make that film, I need to actually I need to be able to comment on The Godfather and get some images from The Godfather to rip some clips. So now, thanks to this exemption, I could do that if I wanted to make my film about the relationship between gangster films and real life. So there are several exemptions currently in effect for accessibility reasons. The key one is literary works distributed electronically can be essentially converted into accessible formats under this exemption. So the last thing I want to talk about is just the Marrakesh Treaty. So the Marrakesh Treaty is an international treaty done by several different, are we doing okay? Yeah. Okay, several different, many different countries. It's administered by the World Intellectual Property Organization, which is a UN agency, and basically it requires member states, which we are one of them, to create a limitation in the law that allows people to make a copy of work in an accessible format for persons with print disability. So it's actually quite similar to the Chaffee Amendment. And I'm not going to get into the weeds, but it also allows exchange across borders of those accessible copies, right? And there's lots of initiatives based on this to try to get works into the developing world from the developed world in particular. And so we have passed a law here in the United States, the Marrakesh Treaty Implementation Act, and that is Section 121A. So we have the Chaffee Amendment, Section 121 to the Copyright Act, and now we have 121A, which says what you do in 121, you can now share with people in other countries who are members of the Marrakesh Treaty. And so with that, I want to actually introduce again my co-panelists and thank them for joining me up here. So Carolyn, Bob, do you want to maybe say a little bit about yourselves and where you're from, and then we can get into it.
Sure, that sounds great. So hi everyone, happy to be here. I'm Carolyn Desrosiers from Scribely, and basically what we do is we're a vendor that helps publishers, specifically with making their images accessible within their ebooks. So we have a team of human writers who are focused on writing for other humans, and we are describing images all day, every day. And the reason why my company exists is because this is a challenging accessibility requirement. Within the publishing organization, given the resources and the bandwidth, oftentimes there really just isn't a dedicated team for this task, right? It doesn't seem to fit with editorial, it doesn't fit with the production team, no one really feels comfortable touching it, and so thus my company exists, Scribely. So I feel like we represent part of this conversation, but more so, the work that I'm doing has to do with meeting the Web Content Accessibility Guidelines. Now, how many people in this room have heard of WCAG? Okay. So WCAG is the global gold standard for accessible content. So the content that we're creating on the web, there are actually standards that we need to follow to ensure that that content is accessible to everyone. So publishers need to actually follow these guidelines, and part of those are actually creating these descriptions for images. So WCAG success criterion 1.1.1 is alternative text for images. Anything that comes in image form needs a text alternative. So you actually can't achieve any level of WCAG, A, AA, or AAA, without adding alt text for images. So this is the very, very fundamental requirement of accessing content on the web. So that's just an introduction to me, and maybe I'll pass it over to Bob at this point.
Thank you, Carolyn. Thank you. Bob Martinengo. Anybody else here was at the 2007 Tools for Change conference in San Jose? Make some noise. Hey, 2007. Pretty cool. Anybody in 2007 was still in high school? Get off my lawn, kids. I'm formerly in Georgia Tech at a place called Alternate Media Access Center. I've been away from there for a couple of years. And I wanted to thank the PageBreak folks for giving me a chance to be on this panel. As I said, well, if I'm going to be on this panel, I want to represent somewhat of a minority view, because back at 2007, I felt that the JP amendment was mistimed. It was a bad idea. It really was kind of stunk, because this is when innovation in ebooks was taking off. This is right. This is when, if you could cast your mind the Wayback Machine there to that time with Rooster's help or not, when we were seeing a lot of development. The first ebook conference was anybody at the Seibold conference, Seibold, and I think it was 2001. It was here, I believe, in San Francisco on ebooks. So that's really going back there. My position that I was espoused then, and 2009 when the Copyright Office was looking for feedback before the Marrakesh Treaty had even been formalized, was that it was creating a division. We were having two paths. One was that, and here in the state of California, we were asking publishers, we being community colleges at that time and all the other college systems, we actually had a law. We were asking publishers for their help with electronic files. At the same time, the Chafee Amendment created a separate path where nonprofit entities, these known as authorized entities, were basically then no longer beholden to copyright, right? They could basically make their own, go their own path. And the organization I worked for at the time, Recording for the Blind and Dyslexic, actually, when I started there in '96, that was right after Chafee, there was a huge backlog of books that they had received permission for to make, and it wasn't, copyright itself wasn't the barrier. That's not to say there weren't some books that probably the Chafee Amendment helped them produce, but just that there were far more books than they had the capacity to produce. Kind of the breakthrough with the Chafee Amendment was an organization called Bookshare, which started in 2002, and basically brought the technology up to speed, right? Bookshare focused on electronic books and making them accessible, and they've been incredibly successful with that. So we'll get back to that point, but really I wanted to say that I felt at the time, in 2007, Tools for Change, that we had two paths going on. If we didn't find a way to bring those together, that people with disabilities would sort of have a walled garden. There would be a lot of content created under a copyright exception that could never be integrated with mainstream commercial content, and publishers would have a hard time breaking back in and getting those people with disabilities back as customers. And I feel that I have sort of been justified in that. Their Bookshare has been incredibly successful. They have over 1 million titles that are available to their members, but you have to have a disability to access those. So those books do not generate any revenue for the publishers. There's no mechanism for members of Bookshare to purchase the books. They simply download them and get to keep them for free. So that's kind of why I'm here, is to sort of say, folks, if you want to have people with disabilities as customers, you need to go get them. You need to earn them. And that Bookshare and other nonprofit agencies, these authorized entities, have an incentive to keep them, keep them sort of within that walled garden.
And Bob, I actually have a similar but different critique. And maybe it was complimentary to yours and maybe not, and I'm sorry that folks over there can't see us, but to me, so what does the Chafee Amendment do? It says authorized entities can go ahead and make copies and then distribute them to print disabled individuals. That's good, right? But really what we're doing, when we have the ADA, we don't say, hey, folks who have mobility issues, the law will allow you to cut your own ramps in and build your own ramps into all the restaurants, right? Instead we say, no, the restaurant needs to do it. The city needs to do it, right? The FCC tells broadcasters, you need to do closed captioning, and you need TV set makers need to build closed captioning into your products. Here we say, hey, authors, publishers, you can have you have these incredibly powerful rights to prevent people from making copies, making derivative works, from publicly displaying or performing your work. And I think I'm forgetting a couple of rights, even though I'm a copyright nerd. It's a very powerful right, and it lasts for 95 years if you're a corporation, and the life of the author, and then the heirs get to hold on to those rights for another 70 years. But we didn't say with that right comes a duty to make accessible copies, right? Instead, we said, hey, if you want to do self-help, the publishers finally can't sue you, or rights holders finally can't sue you. And so this is approaching Bob's point from another perspective, and I think it's a flaw in copyright law. At the same time, we do have a lot of robust provisions in the law that allow those kinds of self-help measures, and there are major organizations that are doing this at scale. So maybe it's a tempest in the teapot, this criticism, but maybe it's a way to rethink, well, what are we, is this really the right, is Marrakesh and the Chaffee Amendment and these other, essentially what I consider self-help, freeing someone to do self-help, the right way to go about it? And then Carolyn, I think, has a different perspective.
Yeah, so when it comes to legislating accessibility, we have the Americans with Disabilities Act, right? It was enacted in 1990, and it says that we cannot discriminate on the basis of disability. And the question since then, because it was 1990 and we didn't have the web at the time, is, well, does that apply to content on the web? Is the web a place of public accommodation in the same way that we found, buildings to be? And so we've been talking about this for many years, and there have been some landmark cases that have basically determined, yes, websites are web content, this is a place of public accommodation. So at this point, we have a legal precedent that tells us, yes, that is true. But when it comes to actually defining what that means, accessibility, the Web Content Accessibility Guidelines, that's where it gets a bit murky. The ADA does not actually define that websites need to meet these guidelines. So that's where we've kind of gotten into this gray area where folks are confused. If I want to create accessible content, how can I do that? To what guidelines? So my company helps publishers meet those guidelines, which are the global gold standard for accessibility. And they are seen as the best practices to follow. If you are committed as an organization to improving the accessibility, follow these guidelines, and you are doing the right work.
I want to make one more point about Marrakesh then, because I think it's a topic well worth discussing, or kind of going in a little deeper, which is that the way the law is written, again, as Jack pointed on the Chaffee Amendment 96, there's nothing really in there preventing an authorized entity, a nonprofit entity, from taking an accessible work that already exists and reproducing it. It's just, Jack, you might, if you want to put in a legal opinion on that, I'd be interested to hear it. But in other words, it's the letter versus the spirit of the law. The spirit of the law clearly is for nonprofit entities to make works accessible that are not accessible. But the letter of the law does not actually prohibit them from taking accessible work and copying it. So, and you think that I'm not accusing exactly somebody, Bookshare and these other organizations like, it's called Learning Ally is what Recording Group Blind turned into. They're not going to do that, because that would actually cause probably a lot of consternation among the publisher members. But now Marrakesh Treaty is a worldwide global initiative, and there's nothing really stopping some of these organizations from taking, let's say, an audio book that exists and making a copy so that they can be given freely away to people with disabilities. That may not be a bad thing. It's not necessarily a terrible thing, but I believe the way the law is written, without any sort of check or balance against commercial availability, to see if one of you folks, if you put in the effort to make your work accessible to be sold to a public library or to retail or to be given away, then I believe that should be the end of it, that should be the copy of record, and that a nonprofit agency shouldn't be able to make a copy of that and distribute it to people with disabilities just because the law allows them to. So, again, that's why said my biography, I can be a little bit of a troll, but I think that was okay. That I was going to point out these things, saying my other favorite analogy about the emperor's no clothes, that this JP and Marrakesh Treaty don't actually produce anything. They just simply open the door for these productions to be done. These nonprofit entities still have to find the resources.
They also don't require it.
That doesn't.
They also don't require anything
Right.
other than saying you're not allowed to sue.
You're right. They have some restrictions. They have to be only for people with disabilities. But these nonprofit agencies still have to go and get resources. And those resources, I have to wonder, would those resources be better directed to the publisher to help a publisher become more accessible? And actually, Bookshare does some interesting work in that way, because their funders says, you folks need to go out and actually help train publishers. And there are publishers who've taken advantage of that to make sure their products are more accessible. So I'd like to see more of that. I'd like to see resources and legislation directed towards helping publishers, as kind of what Jack said, is his point, reach that market. I don't think we need more money going to nonprofits to essentially build collections of segregated books. Okay, should we open it up for questions at that point?
Yeah, I think that makes sense.
We got a few more. We got 5 minutes till 10 time.
Okay, questions. This individual here?
I have a question about library lending, because I'm a publisher and we get like a very small percentage, right? So it's like 20 cents on the book when it's lended. And so do these libraries then have some kind of limited capacity?
I just would be curious about how that works, because you're saying, oh, I'm in Irvine, I can lend from San Francisco, but does every library set its own quantity of the number of library books it can lend?
So my understanding of this program called Controlled Digital Lending, which is at the heart of this lawsuit, which is what this lawsuit is about. That these parties are fighting about, is that once they purchase a physical copy and however much you get, then that copy maybe could be loaned out physically, but and so if other people, if I'm wrong, please speak up. But that physical copy, instead of being physically lent out, would then be digitized and lent out virtually, one at a time, right? So we could have a waiting list, first me, then Carol, and then Bob, and I get it for a week, and if I turn it back in after 3 days, now Carolyn can access it, and then after I turn it back in.
I guess my question is about publisher compensation.
I mean, I don't know that I don't think they are compensated, and I think that's one of the reasons why they're upset.
Yeah, so there's
we sell licenses for books for ebooks to libraries that have terms that say, you buy this from us for $45 and you can lend it out 26 times.
Right. So what this individual said is, that right now publishers sell licenses to libraries that say that have license to ebooks that have specific terms, right? You paid X amount, or you only can loan it out a certain amount of times. And what the Controlled Digital Lending Program does is it simply says, no, we're going to treat this like these people are coming into the library and checking out a physical copy, if I understand it correctly.
Yeah, that's basically
But they
right.
bought the physical copy.
But there is a physical copy sitting
Right.
in the library's
Which
archives.
presumably they have paid for.
Which presumably they paid for, or they bought a used copy somewhere, which is of course legal to buy the used copy.
Yeah, the publishers are contesting because, or one of the reasons they're contesting is because some of the copies in Controlled Digital Lending, as the Internet Archive implements it, have active digital editions on the marketplace, right? So Brewster, principally, the competition gets very complicated very quickly, but Brewster particularly asserts that he has a paper copy of a book and therefore is able to digitize it and make that digital copy available on a one copy, one loan basis. So this one copy, one loan basis is at the heart of the Internet Archive's position about their ability to do controlled digital lending. And notably, unlike some European countries, there's no public lending right. So some countries have various schemes whereby ultimately authors may get compensated for on a loan basis that occurs through libraries, and that does not exist, and it's frankly not likely to exist in the United States.
I'm with Bob on this one. I work with Bill Kasdorf on accessibility, and the argument we try to make to publishers is, do you want your books going out through Bookshare and you earn nothing on those books, or do you want to reach an enormous community, which too many publishers think, well, there can't be all that many blind people. It's like, that's not the point. The point is there's a huge number of print disabled people who you are not reaching. You're not getting any revenue through Bookshare. You're not selling books to that community for the most part because Bookshare hasn't digitized most of the books that that community is trying to reach. And so if you move towards a born accessible workflow, you're going to probably increase your target market by upwards of 10%. And that by itself pulls out an ROI very, very rapidly. For the publisher, you have to explain that, and it takes a while. And you have to say, well, Carolyn can help you, because she knows how to do this stuff, and there's some really smart people who know how to do this stuff. And once you get over that hurdle, you build it into your workflow. Works great.
Scribely.com.
Before starting Scribely, I worked for Sage, and I got a really interesting view into educational publishing. And I saw the early stages of educational publishers taking these steps to make their ebooks more accessible. And at this point, many of them are very far along in that process, where they are looking at the web content accessibility guidelines and taking the steps to make their ebooks accessible. I see Evan here, who really was a champion in this area from years back. So steps have been taken to make content accessible on the web. And it's because, yes, we want to reach as many readers as possible. And also, this is important to universities because they are required to make sure that the materials that students receive are accessible. So really this supports readers, it supports the universities, and everyone benefits from it. So when we think about accessibility, we try to push it forward and make progress. Then I think at the end of the day, we're all on the same side and we're reaching as many readers as possible.
It says amen and virtual mic drop.